Sir. Thank you so much, sir, for the elaborate lecture on the aspect of TRIPS and its significance to intellectual property. We have one question from Mr. Satyendra. The question is why the TRIPS agreement doesn't require all its members rules on protection of intellectual property to be identical. It prescribes only to comply with certain minimum criteria, minimum standards for the protection, but does not emphasize or does not prescribe identical protection.
I got it.
The opinion is, sir, because of this, there is room for inventions to be copied by another country's person by the time they are patented or registered, both nationally and internationally by the inventor.
Okay, good question. I can tell you why uniformity was not. That mostly every country has their own domestic legislations. The intellectual property, I said in the beginning of my class, it began with domestic enforcement. Then later on, certain problems happened, and then international treaties happened. What was the problem? Problem was harmonization. Every country has their own domestic law. When cross-border IP is happening, how to regulate, how to enforce it was a big challenge. That's why the international regime came. But international regime, whether it's a TRIPS agreement or anything, it sets minimum standards. That's why I said first the features of TRIPS agreement. And when I was talking about, I was mentioning about the standards, dispute settlement, those things, standard. It sets minimum standards. Beyond that, of course, countries can go. Not 100% they have to follow, they have to. So these are all minimum standards, and beyond that, it is the individual member countries which they can modify or they can change. So that is the reason why there is a scope. And friends, one issue again, problem with international treaties, international law is that if you start uniformity, if you want to mandate everything, again, its implementation is very difficult. Here, since you asked, the approaches for implementation of international intellectual property should be different from domestic. Domestic law, parliament can make law, executive implement law, no problem. If any violation, police is there, contempts are there. But these things are not there. That's why in international context, if you look at any, as a you student or I am student or advisor, we need to have a different approaches for effective enforcement of international intellectual property law. What are those new approaches? Cooperation, coordination, consensus, convincing. These are the methodologies which we have to adopt. The danda, in the domestic law, danda will work. Okay, but international law, cooperation, coordination. That is where certain leverages which we have to give, and we don't expect 100% or uniformity. So that is the thing. Yeah, I get it.
Now another question from Mr. Akshit Soni. Okay. Are GDPR rules related to IPR? If yes, in what way it affects the IPRs?
Mostly that is a cyber security related thing. Basically, that now, of course, we have these new legislation taking a clue from the GDPR side. Morely, it's a European approach for protection in general, and mostly the GDPR rules which talk about the cyber security, privacy related things. Of course, you all know that we have the legislation which is pending in Indian Parliament. Okay, privacy, data protection. These are all general IP and general security related things. IP is part of that. There's no doubt. But Indian the data protection legislation which is pending in the Parliament, which also took some of the clue and some of the I can say approaches which GDPR followed in India, we are also following, but which was mostly relating to the security aspect and more relating to cyber security, data protection, privacy. Those are all things which GDPR which talks about that.
Thank you, sir. Next question we have from Mr. Panir Selvam. Sir, what is the international protection for performers' rights and how effective is that protection?
Of course, performers' rights is a good question again. Friends, I said, patents, copyrights, okay, or, intellectual property, I said two categories. One is particularly patent, trademarks, design, which dealt by the Paris regime, Paris Convention, Paris regime, I said. Berne regime deals with, I said, copyrights and related rights. It is a new thing actually. Related rights is the new contribution which was made by the TRIPS agreement. Earlier, they didn't talk about the related rights. Related rights, three related rights important. rights relating to performers, producers of phonograms, and designs. So these three copyright related rights are neighboring rights also. We call neighboring rights. So these rights, you have a different regime, and that regime is basically provided by TRIPS agreement, or protection given by the TRIPS agreement. It's a new entry. That is where whole IP we have a two categories. Traditional IP carries burn WIPO regime basically. Modern IP you have a TRIPS WTO regime, where the new IP regime, which more particularly because technology is evolved, neighboring rights are copyright, performers, producers of phonograms, these things are part of the new technology. That's where the new approach, part of the TRIPS agreement they provided, not earlier treaties. So that the new contribution or new addition, I can say that part of the TRIPS agreement.
Thank you so much, sir. We have another question from Mr. Prakhar Dubey. Sir, what is the link that we can draw between artificial intelligence and IPR?
Of course, this is, friends, actually generally talking about law technology. Law follows technology, or technological developments needs law. Today, unfortunately, law is, technology is moving fast. So we call, these emerging technologies, okay? I call them as A to Z technologies. What do you mean by A to Z technology? Start from A alphabet, artificial intelligence, Bitcoin technologies to cyber, all this. Today we have a new and emerging technologies, the word we use. Part of that many technologies which are happening, artificial intelligence is important among, these A to Z technology. I am using my own word, A to Z technology. Artificial intelligence, IP is part of everything. So, you can't disassociate or, deviate, from the IP. Even artificial intelligence, so much technology is development. They need to protect their own intellectual property. So I don't know, but what context you are asking, but part of the artificial intelligence IP is anything, that's where I was talking about Article 2, Clause 8 of the WIPO Treaty, which made 7 important categories of definition. Everything, including, if you look at last definition of that thing, if anything included, all inventions of mankind, they provided. So this artificial intelligence is an upcoming technology, part of the new and emerging technologies. For protection of, artificial intelligence is a very important. There is no doubt, and of course, a lot of work is happening in that direction.
Yes, thank you, sir. Sir, there is another question with respect to the amendment that has been made to the TRIPS agreement in 2017. The 2003 decision with respect to improving poor countries' access to affordable medicines, the amendment makes a permanent decision on patents and public health, which was adopted in 2003. Sir, what is your opinion as to if this 2017 amendment has been effective in its operation?
Of course, effective, ineffective, that is depend on the enforcing agency. But to comply with one of the challenge with the TRIPS agreement compared to other international treaties, is that one word I used, transparency and reciprocity. I used the word, part of the fundamental principles of TRIPS agreement is transparency. So when you say that transparency, when you say that surveillance, so TRIPS agreement supervise every 2 years the progress of the member countries. That is where I use the word trade policy review mechanism. One of the agency was created, part of the TRIPS agreement, not mentioned in other agreements, is every 2 years WTO member countries meets and review the situations, all trade related, including intellectual property. They review, they revisit, and they say that which country implemented, which is not implemented, and why it is not implemented, what kind of help they require. And other beauty relating to this thing is there is a council for TRIPS. That is the organization which takes care of all these implementation procedures adopted by the member countries. They have to, like I said, so some deviation is of course allowed, permissible, but otherwise also general philosophy of any international treaty, I said, friends, it is a voluntary thing. Once you voluntarily accepted, you have to implement. How will you implement? You have to make domestic legislation, all these things. I think effectiveness compared to this, you're mentioning about the new amendment, all this, we have to. Otherwise, one important principle in the TRIPS agreement is there, that you can't go against the philosophy which, part of the TRIPS agreement. So meeting those philosophy, those basic, structures, we can implement, in the domestic context. And I'm true, we have to make amendments to that because these are all new additions. That's where we use the word TRIPS plus. When, TRIPS happened in 1995, I know, and after that, so many developments which, happening, and member countries are implementing through, enforcing through their domestic legislation, amending the existing domestic legislations. So we had to be part of that. Amendments is part and parcel of the TRIPS compliances. I said compliance.
Yes, sir. Thank you, sir. Now I would request the chair professor of the DPIIT IPR chair, Osmania University, Professor GB Reddy, sir, to please give his remarks. And also, sir, with respect to the filing of the patent application, if you could elaborate on that, that would be nice.
Thank you, Irfan. And thank you, sir, for an excellent, presentation on the protection of IPRs during the post-TRIPS scenario. And in fact, the questions raised by some of the participants regarding the TRIPS Ministerial Council and the territoriality of the IPR protection and the other related areas are very well explained and clarified by you. And probably now most of the countries, including India, they've got nothing to do or nothing more to comply with the TRIPS obligations, because we have complied with them totally by 1/1/2005, at least as far as the patents are concerned. And with regard to the copyright, we always have been providing TRIPS plus protection, TPP. I think even today we have a similar system, and I'm sure that the questions raised by the participants are worth considering, and your association with this particular series is much more valuable to us. And we expect many more lectures from you, probably mostly on the trade related issues, because your observation that IPRs without the trade nexus, ultimately it remains only a rhetoric or purely the moral rights. That's not the case as far as the trade related aspects of intellectual property rights are concerned. New areas are emerging. Probably your observations on the race between law and technology are also very illuminating. So I, on my personal behalf, thank you for joining us and spending your precious time on a weekend. I know how busy you are, but I think our participants have got more than they deserve from your association and wonderful presentation.